Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Mark Watkins, decided May 23, 2024. Halligan, J. Defendant Mark Watkins contends that his trial counsel was ineffective for failing to request a cross-racial identification instruction at the close of his July 2017 trial. Under our decision in People v. Boone decided after Watkins' trial, such an instruction is now mandatory upon request when identification is an issue in a criminal case and the identifying witness and defendant appear to be of different races, in light of the higher likelihood of misidentification and the significant disparity between what the psychological research shows and what uninstructed jurors believe regarding the impact of this cross-race effect. At the time of Watkins' pre-Boone trial, however, a defendant was not entitled to a cross-racial identification instruction upon request, rather, the charge was discretionary. Thus, counsel's failure to request such a charge did not give rise to a single error ineffective assistance of counsel claim. Accordingly, we affirm the order below. 1. In July 2017, a jury found Watkins guilty of assault in the first degree, assault in the second degree, and criminal possession of a weapon in the third degree. The charges stemmed from an October 2016 incident in which 65-year-old David Pena was approached by a stranger on the street and struck in the left cheek with a hard object, fracturing his orbital bone. Pena was not looking at the assailant at the time of the attack, and when he was hit, he immediately retreated to a nearby basement to retrieve a wooden stick to protect himself. Upon returning to the street, Pena observed the assailant's face for a period of a few seconds before the assailant turned and walked in the other direction. When Pena reported the attack 3 days later, he described the assailant as a black man who was not much taller than him and wearing black or brown pants, a white t-shirt, tennis shoes, and a hoodie. The police showed Pena 462 mugshots, none of which depicted Watkins, and Pena indicated that he did not recognize his attacker among them. 2 days later, Pena called 911 and reported that he had spotted his attacker on the street. The police detained a man matching the description Pena gave, but Pena later informed the police that they had detained the wrong person. The next day, Pena again contacted the police and reported that he had seen his attacker on the street. When the police arrived, Pena pointed across the street to Mark Watkins. Watkins was then arrested. At trial, the only identification evidence was the testimony of Pena, who identified Watkins as his attacker. Pena also testified that Watkins was the man he pointed out to the police on the day of Watkins' arrest and the person depicted in surveillance footage of the attack. The surveillance video introduced at trial confirmed Pena's account of how the assault happened, but the parties and the trial court agreed it was too blurry to depict the assailant's face. Defense counsel argued honest but mistaken misidentification. During the charge conference, the people requested the witness plus identification charge, which is to be given where identification is an issue but is not premised solely on the testimony of one witness. That charge was appropriate, the people contended, in light of surveillance footage allegedly indicating that Watkins was the perpetrator. Defense counsel instead sought the one witness identification charge, an expanded charge that includes 2 additional paragraphs directed at cases in which the identification rests entirely on the testimony of a single witness. The trial court agreed that the surveillance footage was not sufficiently probative as to identity and accordingly instructed the jury pursuant to the one witness charge. Before us, the parties agree that Watkins' identification was cross-racial in nature. They characterize Watkins as black and Pena as non-black Hispanic. But at trial, there was no questioning on this topic or expert testimony on cross-racial identification. Defense counsel did not request inclusion of the cross-racial portion of the one witness identification charge, and the court did not include it. On appeal, Watkins argued, as relevant here, that he was deprived of the effective assistance of counsel because his trial attorney did not request a cross-racial identification charge. The appellate division affirmed, holding that Watkins' ineffective assistance of counsel claim is unreviewable on direct appeal because it involves matters not fully explained by the record. Alternatively, the panel concluded that, to the extent the existing record permits review, Watkins received effective assistance under the state and federal standards because he has not shown that it was objectively unreasonable for counsel to refrain from requesting a jury charge on cross-racial identification. Noting that Boone had not yet been decided at the time of Watkins' trial, the panel stated that he had not shown that such a request would have been granted at the time of the trial, or that the absence of such a charge affected the outcome of the case. The sole claim before us is that defense counsel was constitutionally ineffective for failing to request the cross-racial portion of the expanded eyewitness identification charge. To prevail on a claim of ineffective assistance of counsel under our state constitution, a defendant must establish that counsel failed to provide meaningful representation and thus deprived defendant of a fair trial, People v. Clark. The meaningful representation standard requires an assessment of the evidence, the law, and the circumstances of a particular case, viewed in totality and as of the time of the representation, People v. Baldy. Counsel's performance should be objectively evaluated to determine whether it was consistent with strategic decisions of a reasonably competent attorney, People v. Benevento. The defendant bears the burden of showing both that counsel's performance was constitutionally deficient, People v. Ragg, and the absence of strategic or other legitimate explanations for counsel's challenged actions, People v. Rivera. Unlike the federal constitutional standard, which requires a defendant to show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different, Strickland v. Washington, the focus of our state standard is on the fairness of the proceedings as a whole, People v. Stultz. Thus, we treat prejudice as a significant but not indispensable element in assessing meaningful representation, People v. Caban. In that respect, our standard is more protective than its federal counterpart because under our state constitution, even in the absence of a reasonable probability of a different outcome, inadequacy of counsel will still warrant reversal whenever a defendant is deprived of fair process, People v. Alvarez. This appeal presents an ineffective assistance of counsel claim based on a single alleged error. A single error may qualify as ineffective assistance, but only when the error is sufficiently egregious and prejudicial as to compromise a defendant's right to a fair trial, Caban. See also People v. Turner. The single failing in an otherwise competent performance was so egregious and prejudicial as to deprive a defendant of his constitutional right to the assistance of counsel. Such cases are rare, Turner, and typically involve the failure to raise a defense so clear-cut and dispositive that no reasonable defense counsel would have failed to assert it, and it must be evident that the decision to forego the contention could not have been grounded in a legitimate trial strategy, People v. McGee. See also Turner. Omitted defense was clear-cut and completely dispositive, People v. Harris. We have held that an omitted argument does not constitute a clear-cut and completely dispositive defense for purposes of a single error ineffective assistance claim where its success depended on the resolution of novel questions, People v. Bruner, where there was a question that remained open in this court but a similar contention had been rejected by the appellate division prior to the defendant's trial, and where the argument did not have clear prospects at the time of the representation, People v. Burrell. Of particular relevance here, in People v. Keshner, we concluded that although the court's flawed charge on accomplice liability may have constituted reversible error if preserved, the omitted argument was not so compelling that a failure to make it amounted to ineffective assistance of counsel, quoting People v. Carter. Similarly, in People v. Blake, we concluded that, although it might have been a mistake not to request an adverse inference charge regarding missing evidence before such an instruction was mandatory upon request, it was not one so obvious and unmitigated by the balance of the representational effort as singly to support a claim for ineffective assistance. By contrast, in the few cases where we have granted relief on a single error ineffective assistance of counsel claim, counsel failed to raise an argument that would have conclusively entitled the defendant to a specific action by the trial court. For example, in People v. Turner, appellate counsel failed to raise an ineffective assistance of counsel claim that trial counsel, in turn, had omitted a meritorious statute of limitations defense. We noted that the defense, a clear-cut and completely dispositive one, would have prevented the charge, against the defendant, from being submitted to the jury. Similarly, in People v. Harris, trial counsel failed to seek dismissal of a time-barred charge, though doing so would have been a certainly efficacious means of avoiding conviction on that offense. Most recently, in People v. Debelis, trial counsel failed to request a charge on the only defense supported by the trial testimony where the defendant would have been entitled to the instruction upon request, and, without it, the jury was effectively precluded from deciding the case with proper consideration of the sole defense advanced throughout the trial. No clear entitlement to a cross-racial identification charge existed at the time of Watkins' trial in July 2017. We had provided general guidance on identification charges in People v. Whalen, which upheld a trial court's decision to give a minimal identification charge instead of the more expansive one requested by defense counsel. We noted there the potential for inaccuracy in visual identification evidence and cautioned that the better practice is to grant a defendant's request and give the expanded charge. Nonetheless, we held that the failure to do so was not reversible error, provided that the court gives a general instruction on weighing witnesses' credibility and states that identification must be proven beyond a reasonable doubt. We reached the same conclusion in People v. Knight, again noting that the better practice is to grant a request for an expanded identification charge, but reaffirming that the refusal to do so is not reversible error where the charge given was a correct statement of the law which sufficiently apprised the jury that the reasonable doubt standard applied to identification, accord People v. Lopez. Thus, as we explained in Boone, entitlement to an identification charge had previously been always a matter for the trial judge's discretion, provided that the trial court conveyed to the jury that the people have to establish the perpetrator's identity beyond a reasonable doubt. Boone. That brings us to the cross-racial identification charge. Prior to 2011, the expanded identification charge included in the pattern criminal jury instructions, CJI, which trial courts had the discretion to modify or refuse to provide, did not include the cross-race effect among the list of factors for the jury to consider in evaluating the accuracy of an identification. In February 2011, the New York State Justice Task Force recommended an instruction regarding the cross-race effect. New York State Justice Task Force, Recommendations for Improving Eyewitness Identifications at 5/2011. That same year, a model charge on cross-racial identification was added to the pattern identification charges in the CJI, with a notation that both the American Bar Association and the New York State Justice Task Force had recommended such a charge be given if a cross-racial identification was an issue, regardless of whether there was expert testimony on the topic of cross-racial identification. In December 2015, a judge of this court granted leave to appeal in Boone, which presented the question of whether the trial court committed reversible error in denying a request for the cross-racial portion of the expanded identification charge. Prior to this point in time, the appellate division had repeatedly upheld the denial of a request for the cross-racial identification charge, sometimes noting that the defense never placed the issue in evidence during the trial. People v. Boone, upholding trial court's denial of request for cross-racial identification charge where there had been no expert testimony or cross-examination concerning a lack of reliability of cross-racial identification. See also People v. Best, People v. Washington, People v. German, People v. Ellison, People v. Applewhite, People v. Jenkins. That practice continued after leave to appeal was granted in Boone, including in the months shortly before Watkins' July 2017 trial, see for example People v. Lee, People v. Dingle. Indeed, the parties point us to no New York appellate precedent that existed at the time of Watkins' trial holding that a trial court abused its discretion in denying a request for the cross-racial portion of the expanded identification charge. In December 2017, approximately 5 months after Watkins' trial, this court reversed in Boone. We left in place the approach set out in Whalen and Knight for eyewitness identification charges in general, reiterating that whether to give the expanded charge is discretionary, but it is better practice to grant defendants' request for such a charge. Yet we concluded that recent developments in the understanding of wrongful convictions and cross-racial eyewitness identifications demand a new approach to instructing jurors on the accuracy of cross-racial identifications in particular. We recognize that there is now a near consensus among cognitive and social psychologists that people have significantly greater difficulty in accurately identifying members of a different race than in accurately identifying members of their own race, which heightens the risk of wrongful convictions in cases involving cross-racial identifications. For that reason, We held that a cross-racial identification instruction would be mandatory upon request in a case in which a witness's identification of the defendant is at issue, and the identifying witness and defendant appear to be of different races. Our characterization of this rule as a new approach to the specific challenges of cross-racial identifications is notable. Boone. Though a cross-racial identification charge had been recommended by both the American Bar Association and the New York State Justice Task Force and added to the CJI, as the dissent notes, C. Troutman, J., dissenting Op. at 7, this court's precedent had long vested the trial court with discretion over the content of an eyewitness identification charge, C. Whalen, Knight. The appellate division had relied upon that precedent to consistently uphold the trial court's exercise of discretion to omit the cross-racial portion of the identification charge, where the defendant neither introduced expert testimony regarding the cross-race effect nor cross-examined the people's witnesses about their ability to identify people of the defendant's race, see for example People v. Boone. Therefore, we cannot say that a legal argument in support of the cross-racial identification charge had clear prospects at the time of the representation, Burrell, or was otherwise so compelling that a failure to make it amounted to ineffective assistance of counsel, Keshner. Given the state of the law at the time, the decision to forego a request for the cross-racial identification charge was not the kind of egregious single error that rises to the level of ineffective assistance. Caban, see also Clark. Trial counsel not ineffective for failing to object to practice that lower courts had sanctioned based on precedent from this court. Today, as in Boone, we reiterate the importance of instructing jurors to examine and evaluate the various factors upon which the accuracy of identification depends, including the cross-racial nature, if applicable. Boone. We continue to view the cross-racial identification charge as a powerful tool for assisting juries in determining whether there has been a mistaken identification, thereby reducing the risk of wrongful convictions caused by the cross-race effect. Still, Watkins has not shown that, as of July 2017, the failure to request a cross-racial instruction rendered his counsel's performance constitutionally deficient. For that reason, we must affirm the decision below. We have no occasion today to opine on the viability of a similar ineffective assistance of counsel claim premised on the failure to request a cross-racial identification instruction after our decision in Boone made such a charge mandatory upon request. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Halligan. Chief Judge Wilson and Judges Garcia, Singas and Canataro concur, Chief Judge Wilson in a concurring opinion. Judge Troutman dissents in an opinion, in which Judge Rivera concurs in a separate dissenting opinion. Decided May 23, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law